Welcome to our deep dive in the English law of contract. This podcast takes you in some detail through contract terms and the significance of their violation. We start with an explanation of what constitutes a breach of contract and then consider what remedies are available as a response. We then examine the operation of exclusion and limitation clauses. We cover all the basics one needs to understand in order to prepare for an undergraduate law exam or the solicitor's qualifying examination. Challenge yourself to stick till the very end and make some notes as you are getting along. If you are looking for explanations of particular concepts, use the chapters noted in this video to jump to the topic you need. This podcast was prepared by Dr. ioannis.glinavos with the use of AI tools. Get in touch with Ioannis, following the information on the video's description, to learn more about how this podcast was generated. Any discussion on remedies needs to start with an attempt to define what constitutes a breach of contract. A breach of contract can be summarized as the failure of a party to a contract, without a lawful excuse to perform their contractual obligations. An example of a lawful excuse would be frustration. A breach of contract gives rise to secondary obligations, to pay damages, and exceptionally, the party at fault may be forced to perform the obligation by an order of specific performance. A contract can be breached in a variety of ways. Firstly, a party may refuse to perform all or part of the contract. For example, someone refuses to pay for goods received. Secondly, performance would be defective. For example, you order a tablet and it arrives broken. Thirdly, a party may be unable to perform the promised actions. The seller has sold the goods promised to you to someone else. Note, however, the requirement that the failure to perform needs to be without a lawful excuse. If, for example, you refuse to pay for the tablet you ordered because it arrived in an unsatisfactory condition, this may not be a breach, as you may have a lawful excuse. We explore this further towards the end of the lecture, when we discuss the right to terminate. Who needs to prove what happened? The burden of proof is on the party alleging breach. For example, if I think that you have not performed your obligation under the contract terms, I will have to prove it. How can one tell if contractual performance has fallen below what is acceptable? How does one define acceptable? Contractual performance is assessed objectively using two standards, those of strict liability and reasonable care. If with the contract the party guarantees a particular result or to bring about a particular state of affairs, if performance fails short of the stipulated standard, there is a breach even if it is not the fault of the party. It is important to remember that one is not looking for moral culpability, intention, or fault. An illustration is the case of F.W. Moore & Company Limited versus Landauer & Co., 1921, which involved a contract to deliver 3,000 tins of fruit to be packed in cases containing 30 tins each. When some of the consignment was delivered packed in cases of 24, this was held to be a breach of contract. Even though the performance was as valuable as the one promised, it was not what was promised, and the buyer could reject the whole consignment. Note, however, what is known as the de minimis rule, which means that microscopic deviations from the promised performance will not constitute breach, unless they come under a statutory duty to perform absolutely. See Sections 13 to 15 Sale of Goods Act 1979 and Sections 9 to 18 Consumer Rights Act 2015 on obligations as to description, fitness for purpose, satisfactory quality and correspondence with sample in sales of goods contracts. According to these provisions, no matter how slight the deviation, it will be a breach if it comes under the Acts. When the contract does not guarantee the result, then a different standard is adopted, that the party will take reasonable care in carrying out his obligations. An example is Section 13 Supply of Goods and Services Act 1982. Where the supplier is acting in the course of a business, there is an implied term that the supplier will carry out the service with reasonable care and skill. The standard here is still objective because the benchmark is a reasonable person in the trade under consideration. Linked to a discussion on remedies are the consequences termination can have on a contract and the parties. The effect of termination is to release both parties from the performance of obligations which were only due to be performed after the date of termination. Note that termination for breach renders the contract voidable, not void ab initio. The obligation to perform is extinguished, but an obligation to pay damages subsists. The expectation principle is still used as the basis of assessing damages, and the duty to mitigate can in practice sometimes mean that the plaintiff recontracts with the party in breach. The key points about termination are as follows. A breach does not of itself terminate a contract, although all breaches entitle the other party to a remedy. Only some breaches are serious enough to allow the non-breaching party to elect to terminate the contract and seek damages, if appropriate. Terminating a contract is in one sense a form of self-help remedy, because it is a way the innocent party can avoid the consequences of a continued breach without the intervention of the court. However, the innocent party has to be careful, because if she terminates a contract when she is not entitled to do so, then the purported termination will itself be a breach for which they will be potentially liable in damages. In other words, if you terminate the contract when you were not entitled to do so, you are in breach yourself. The other party can terminate and claim remedies from you. We now move on from discussing breach of contract to remedies, starting with damages as the primary remedy for loss. The most commonly used remedy for breach of contract is damages. The aim of damages is to compensate the victim of the breach, not to punish the party in breach. It is for this reason that one will not be able to obtain compensation unless they can demonstrate that they have suffered loss on account of the breach. It is also important to note that the measure of damages is not affected by the motive of the breach. This was illustrated in the case of Ioannis v. Gramophone, 1909, involving someone's dismissal from their employment. While the claimant did get damages for wrongful dismissal, he could not claim damages for the sharp and oppressive manner in which he was sacked. There are three main headings of damages. 1. Expectation loss, meaning protecting the party's performance interest. 2. Reliance loss, meaning compensating party for what they spent. 3. Restitution, meaning recovering the benefit given to other party. Remember that the difficulty in assessing loss does not mean that the claimant loses his right to damages, unless the loss depends entirely on remote and hypothetical possibilities. For example, in Chaplin v. Hicks, 1911, the difficulty in assessing damages for the loss of a chance to win a beauty contest was not considered a bar to the claim, as real loss had been suffered. We will now consider each of the headings of damages in turn. Awarding damages for expectation loss means compensating the party for the loss of his expectations. What would the party gain from the performance of the contract if the breach had not occurred? In Robinson v. Harmon, 1848, the judge said that the rule of the common law is that where a party sustains a loss by reason of a breach of contract, he is, as far as money can do it, to be placed in the same situation, with respect to damages, as if the contract had been performed. This leads to the next question, which is what to claim and how to claim it. In Parsons Limited v. Utley Ingham and Company Limited, 1978, a farm bought some equipment to store food and used to feed their pigs. Because of the way it was installed, a ventilator was left closed, the feed went bad and the pigs got sick. The claimed compensation was for loss of profits from having lost the pigs. There are a number of ways in which to calculate the loss claimed in such a case. 1. Loss of promised performance, meaning not getting a functioning pig feeder. 2. Consequential loss, which could mean a. the dead pigs, the farm being made worse off. 3. Consequential loss. b. the profits that would have been made from the sale of the pigs have been lost, the farm not being made better off. There are two main measures of damages for expectation loss: difference in value and the cost of cure. Difference in value. A common way to calculate the loss the party suffers from the breach is to determine what the party would earn from the performance of the contract if it had been as promised, and deducting what the party actually got. Promised performance. Actual gain equals amount lost due to breach. Remember that the starting point in determining what will be compensated is that compensation will cover the minimum obligation undertaken. This means that you will receive damages, for example, for the minimum gain you would have made under the contract, not for the eventuality that you might be fantastically successful. This leads us to the next question, which is how do you determine what the party would get? One way is to use the market price rule. What do we mean by market price? The first step is to determine the relevant market. When the seller is offering goods for sale and there is a buyer, the transaction is taken as characteristic of the market. When there is no buyer but there are other traders, information from other transactions can be used to determine the market. The second step is to determine the price. This could be a fair price, determined by actual trade or the price that people would pay on that day for the goods or services. For example, let us imagine a situation where we agree that I sell you flowers to make flower arrangements. Because the flowers I gave you are substandard, your arrangements are of lesser value. How much money have you lost? What is in this case the relevant market? It would be independent contractors doing that sort of job, meaning sellers of fresh flowers. What is the price? What these people would normally charge for a similar job, In other words, what would be the price of goods similar to those you ordered. However, the difference in value measure may not always be satisfactory. For instance, what if there is no market? For example, when goods are manufactured especially for the buyer, such as a spacecraft made for NASA, there may be no market to discover prices in. In this case, the court itself will estimate the price. Also, what if the goods are defective but are still retained and used by the buyer? There may not be a market for defective goods of that nature. In these cases, it is necessary to consider an alternative ways of assessing damages. Let us discuss the cost of cure. The difference in value measure, as we saw, examines what valuable performance one did receive and how different it is from what one was promised. The cost of cure measure denotes the excess utility, or subjective value, over and above the market value of the performance contracted for, which would have been secured had the contract been properly performed. In other words, the cost of cure measure asks, how can the defective performance be fixed? How can you get what you bargained for? You may think at this point that if differences value is available, the cost of cure is irrelevant. Why bother having different measures? If both measures are available, aren't they the same? The results of calculations could be the same, depending on circumstances. For instance, as in the example above, we agree that I sell you flowers for £5,000 for you to make flower arrangements to sell. Because the flowers I gave you are substandard, worth only £4,000, your arrangements are of reduced value. A diminution in value measure would calculate the price of what you should get minus what you got. 5,000 minus 4,000 equals 1,000. A cost of cure measure would estimate how to fix the problem, meaning bring the flowers up to expected standard. The cost of this may well be 1,000, say to add more quality flowers. So the result would be the same in both cases. But see following. In Jacob and Youngs v. Kent, 1921, work was carried out in a building and the owner wanted the plumbing to be carried out using a specific type of pipes. The builder used another type of pipe that was just as good, but the owner sued in breach of contract. The court said that yes, this is a breach of contract because the performance needs to match the contractual speculation, and it is not up to the builder to substitute the promised items with things he deems just as good. However, awarding the cost of cure would be vastly different from awarding the difference in value. In Tito v. Waddell, No. 2, 1977, a company was granted a license to mine on an island and undertook the obligation to restore the area afterwards. They did not do it and were sued. The diminution in value for plots of land was minimal as the island was not inhabited, but the cost of cure, returning the island to its original condition, would have been huge. The islanders in this case lost. As the differences can be significant then, how does one choose between the two measures? It could be that statute decides. For example, the Landlord and Tenant Act 1927 determines that tenant's covenant to repair is assessed on the basis of diminution in value. The Sale of Goods Act 1979 Section 53(3) says that diminution in value is the measure for defective goods. Also, case law could determine the cost of cure is the appropriate measure for building contracts when reasonable. We now move on to the second method of calculating damages, that of reliance loss. What is reliance loss? When expectation loss is too speculative, for example, it cannot be proved what you lost from the defective performance, or when you have no loss of profits, you can claim for what you spent in performing your side of the contract. An example is the case of McRae v. Commonwealth Disposals, 1951. The Commonwealth Disposals Commission sold its rights to a tanker that had sunk. It provided the claimant with the details of where the tanker was, and according to the contract, McRae would keep whatever he could salvage. McRae could not find the ship because it was not where the commission said it was. In this case, the claimant could not prove what he lost from the breach because there was no way to tell how much value lay in the tanker. So the only things left to claim were the money paid for the rights to the non-existing tanker, and the expenses in mounting the salvage expedition. What can you claim for under the reliance loss heading? It is possible to claim both pre- and post-contractual expenditure, depending on the circumstances. Let us look at pre-contractual expenditure. In Anglia TV v. Reed, 1972, it was held that the case of wrongful repudiation of a contract allowed the aggrieved party may claim by way of damages not only expenditure incurred after contract but also pre-contract expenditure within the reasonable contemplation of the parties. In Anglia, a well-known actor contracted to appear for Anglia Television to play the lead in a play which they were producing. Shortly afterwards, he wrongfully repudiated the contract, and Anglia Television were forced to abandon the production. Anglia Television claimed the total wasted expenditure, but the actor contended that they were entitled only to their expenditure after the contract was concluded. The court found that the plaintiffs could claim expenditure incurred before the contract provided it was reasonably in the contemplation of the parties as likely to be wasted if the contract were broken. It is important to note firstly that Anglia was claiming Reliance loss because they could not prove what their profits from the production of the film would have been. Secondly, pre-contractual expenditure can be claimed if it was within the contemplation of the parties. Does the claimant have a completely free choice between expectation and Reliance loss? In Anglia, Lord Denning suggested that a claimant needs to make a selection whether he asks for his expectation or Reliance loss. This has caused some controversy, but it appears that what Denning meant by this is that the claimant should not be allowed to claim for the same loss twice. Expectation loss will normally involve a claim for gross profits. What would the victim of the breach get from the performance of the contract? This will include already an assessment of the expenses incurred by the claimant. Further, the courts do not offer compensation for the consequences of bad bargains. As in C&P Haulage v. Middleton, 1983, if someone would have lost money out of a deal anyway, they are not entitled to claim the expenses incurred as a result of making the contract. The reason is that this would compensate them at the respondent's expense for the bad bargain they had made and would leave them better off than they would have been had the contract been wholly performed. A significant question that arises from the above is who needs to prove losses. In principle, the claimant is free to quantify his loss on an expectation or on a reliance basis and has to prove the loss he is claiming. However, if the respondent is claiming that this is a bad bargain and it should not be compensated, like in C&P, then the burden of proof shifts to the defendant. Finally, when do we start assessing damages? The usual time for the assessment of the loss is when the performance became due but did not take place. In other words, the relevant time is the date of breach. We now move on to a series of remedies that come under the broad heading of restitution. Restitution, generally defined, allows the victim of breach to recover the benefit passed to the defendant. A difference between restitution and the other two measures, expectation loss and reliance loss, arises in the case of total failure of consideration. In this respect, this can be a more complete measure of compensation because it allows total recovery of the benefit passed to the defendant. Thus, the claimant gets back the value of his performance regardless of whether that is the whole loss. It usually applies to payments of money for nothing in return. What happens, however, if we are not in the domain of total failure yet there is no obvious loss? We have already seen that the principle in Ioannis v. Gramophone, 1909, is that compensation for breach of contract is for compensating loss, not punishing the defendant or compensating for disappointment. There are, however, cases when the breach results in loss that is not measurable under the two principles mentioned in our discussion of expectation loss, diminution in value and cost of cure. Also, there are cases where the loss is not adequately represented by the use of one of those two measures, because something more is being lost. These cases are known as involving non-pecuniary loss, a loss not measured in money. The general rule is that damages for anguish and vexation were not recoverable, when they arise out of a purely commercial contract. Only claims for physical inconvenience, not mere disappointment, have historically been accepted by the courts. An example is the case of Watson and Other versus Morrow, 1991. The plaintiffs, who were husband and wife, acquired a property as a second home and had required that it should be reasonably trouble-free without any need for extensive repairs. The surveyor's report indicated that the defects mentioned in it could be dealt with as part of ordinary maintenance. However, the plaintiffs discovered costly defects beyond those disclosed in the defendant's report. The court found that the financial loss of the plaintiffs was limited to the difference between the value of the property as it was represented to be and its value in its true condition, and also that damages were recoverable for distress and inconvenience caused by physical consequences of the breach of contract. Damages for disappointment will only be recoverable for select cases of special contracts, whose purpose includes pleasure, as for example a holiday contract, see Jarvis v. Swans Tours Limited, 1973. Things become more complicated if one is trying to claim non-pecuniary losses for commercial contracts, given the historical hostility of the courts as mentioned earlier. What happens then when the victim suffers no loss but the defendant is making a profit from the breach? An example is the case of Surrey CC and Mole DC versus Brodero Homes Limited, 1993, where the court held that when a breach of contract caused no loss to the plaintiff, the appropriate award was nominal damages, meaning no compensation of any real value. However, there are some mechanisms that will prevent the perpetrator of a breach from gaining what is seen as an unjust reward. One such mechanism is an account of profits as seen in Attorney General v. Blake, 2001. The case involved a former member of the Secret Intelligence Services, SIS, who later became a Soviet agent, in violation of his contractual obligations to the British government, wrote the book and entered into an agreement with a UK publisher. The Crown claimed whatever payments were due from the publishers. The court held that in exceptional cases, where normal remedies were inadequate to compensate for breach of contract, it was open to the court to order that the defendant account for all profits either received or to which he is entitled. Therefore, an account of profits is only considered when no other remedy available. It requires a special relationship between parties, e.g. fiduciary, and the fact that the breach is cynical, deliberate, was made to profit defendant is not enough. The test emerging from Blake is: did the plaintiff have a legitimate interest in preventing the defendant's profit-making activity and depriving him of his profit? A slightly easier way around this problem would be to consider how much money would the plaintiff have asked for to allow the action that now constitutes the breach. This is described as a hypothetical release and illustrated by the case of Rutham Park Estate Company Limited versus Parkside Homes Limited and others, 1974. We now move on to consider remedies other than monetary amounts, meaning damages. As we have seen, damages are the main means of compensation for breach of contract. In exception cases, however, the court may order specific performance. This means order the party in breach to perform the contractual obligation. Specific performance is a remedy at the discretion of the court, only awarded when damages are an inadequate remedy. The burden of proof is on the victim of the breach to establish that damages are not enough to compensate for the loss suffered. Why would damages not be enough? Normally, a monetary amount representing the loss will suffice to cover the loss. However, this assumes that, for instance, the victim of the breach can purchase some substitute performance. When substitute performance is unavailable, one may consider an order of specific performance as the only way to effectively deal with the breach. An example is the case of Sky Petroleum versus VIP Petroleum, 1974. During the oil crisis of the 1970s, the claimant had contracted to buy fuel at fixed prices for a 10-year period. When the respondent wrongfully terminated the contract, the court held that damages would not be enough to compensate. Even though petrol is not unique, since it was difficult to come by during that period, monetary compensation would be inadequate in compensating the claimant for his loss. Could the parties agree on future potential damages? The next part of the discussion deals with this issue. We have discussed in the context of remedies that the purpose of an award of damages is to compensate the victim of the breach for his loss, not to punish the defendant. Is it possible then to have penalty clauses inserted into contracts? Penalty clauses interpreted as a punishment for the contracting party in case of breach of contract will not be enforceable. However, if the clause is interpreted as a liquidated damages clause, it will be enforceable as an assessment of the damage that will arise from the breach of contract. For example, in Dunlop Pneumatic Tyre v. New Garage and Motor Company, 1915, Dunlop was selling tyres to the garage and there was a term in the contract that prohibited the garage from selling them for less than the list price. There was also a clause that if the contract was breached, the garage would pay a fixed amount for each item sold to compensate Dunlop by the way of liquidated damages. The court held that this was an acceptable pre-estimate of the loss and not a clause intended to punish the defendant in case of breach, as a penalty clause. The court highlighted that the label used by the parties for the clause is not conclusive, and that a liquidated damages clause is supposed to be a genuine pre-estimate of damages. Liquidated damages, or agreed damages, are not to be confused with an action for agreed sum. This denotes the situation where the claimant is asking for the contract price after having performed his obligation under the contract. The benefit of this action is that it is not subject to the limiting doctrines we will discuss in a moment. Things like losses of profits we have discussed before are called in the literature consequential losses. How to choose what to include in a damages claim is very important and can have very serious financial consequences. Limitations to the kind of damages available include causation, remoteness, mitigation, contributory negligence and kind of loss, meaning that some types of loss are not available, for example, compensation for mental distress in commercial contracts as we saw above. We will in turn discuss causation, remoteness and mitigation. Causation. Only losses that are causally connected to the breach can be claimed. For example, if I miss a flight because I was late leaving for the airport, as I was at home trying to get my laptop to switch on, I cannot pass on the cost of a replacement flight to the seller of the laptop, even it can be proved that the laptop was substandard, in violation of the contract of sale. How much of a connection is needed is explained by the detailed rules on remoteness. Remoteness. The key case on remoteness is the case of Hadley v. Baxendale, 1854. Hadley was the owner of a mill. He contracted with Baxendale for him to carry a part of the machine in the mill to an engineer to fix. Baxendale was late in delivering to the engineer and the mill had to stay closed for an extra 5 days. Hadley claimed loss of profits for the 5 days that the mill was closed. The court held that the resulting loss of profits was too remote a consequence and therefore not recoverable. The court presented the test for allowing consequential loss as a two-part question. I. Is the loss arising naturally from the breach? Or E. Was the loss within the contemplation of the parties? If it arises naturally, then the loss is recoverable. If it does not arise naturally, then the loss is only recoverable if the possibility was known to the parties. But where do you draw the line? A good example is the case of Victoria Laundry, Windsor, v. Newman Industries, 1949. Victoria bought a large boiler from Newman. The boiler was in Newman's shop and had to be disassembled and sent to Victoria. It got seriously damaged during removal and it was 5 months delayed in reaching Victoria. Victoria included in the claim for loss of profits the lost chance of having very lucrative contracts with the Ministry of Supply. The court held that profits from the government contract were too remote. In summarizing the law, the court found the following. The principle of damages is to put the party in the position he would have been, had the contract been performed, expectation loss. This principle pursued without qualification would result however in unfairness to the defendant. In cases of breach therefore the victim can only recover losses reasonably foreseeable as liable to result from the breach. What is reasonably foreseeable depends on the knowledge of the parties. Knowledge for this purpose is of two kinds. A. Imputed equals reasonable assumption that you can foresee things occurring in the ordinary course of things, first part of Hadley. B. Actual knowledge outside the ordinary course of things, second part. The final limiting doctrine we will discuss is mitigation. Mitigation. The victim of a breach is under an obligation to mitigate his losses. If he fails to do so, then the damages award will be reduced accordingly. This means simply that the breach does not give the victim a license to go and spend. Therefore, the claimant needs to take reasonable steps to minimize his loss, but these steps need only be reasonable. The claimant is not expected, however, to go out of his way to make it easier for the perpetrator of the breach. An example of the rule in operation is the case of British Westinghouse Electric and Manufacturing Company versus Underground Electric Railways Company of London, 1912. But what if one could escape the consequences of breaching a contract through limiting their liability? We now move on to a presentation of limitation of exemption clauses. One of the key elements of the study of the law of contract is the treatment of what are known as limitation, exclusion or exemption clauses in contracts. These are clauses that try to limit or totally eliminate the liability of a party in case of breach or deviation from contractual performance. In other words, exemption clauses seek to secure one of the parties from liability for losses due to their breach the other party may suffer. A typical clause most of you will be familiar with is one that says, for instance, you are parking your car at this location at your own risk. The parking garage will accept no liability for loss or damage to your vehicle while in our premises. Such a clause may be found in a notification displayed at the location of a car park, or within the terms and conditions of booking of a hotel room, for instance. While the various types of limitation clauses have a negative reputation, it is important to remember that they are legitimate ways to apportion risks of loss between the contractual parties. Consider, for instance, that the costs of obtaining a service could be higher if the supplier was not able to manage the risk of monetary loss arising from customer claims. On the other hand, as most of these types of clauses are inserted in standard form contracts, prepared in advance of meeting the customer, and not subject to negotiation, there is a high risk that they may unbalance the relationship in favor of the supplier of a product or service. This is why there is quite a lot of detailed legislation regulating the form and content of exemption clauses. This part of the presentation will discuss the place of limitation and exemption clauses in English law, presenting their nature and functions, the way the law treats their incorporation into the contract, case law and statutory controls. We touch upon the treatment of such clauses both in the case of consumer and in business-to-business contracts. The presentation starts by discussing how limitation clauses are incorporated into contracts. Addresses their interpretation through the concept of construction. It proceeds to discuss the statutory treatment of potentially unfair terms through the Unfair Contract Terms Act 1977, UCTA, and the Consumer Rights Act 2015, CRA. Exemption clauses may seek to exclude totally a liability or merely to limit it. The terms exemption clause and exclusion clause are often used interchangeably. In this presentation, we also refer to limitation clauses with the same aim. A party wishing to rely on an exemption clause must show that it was a term of the contract, meaning that it was properly incorporated into the contract, and that, properly construed, it covers the loss or damage which has occurred. This is known as construction of the contractual clause. Even if they can show both these things, the clause may still be affected by the Unfair Contract Terms Act or the CRA. We will start by discussing the challenges present in incorporating exemption clauses into contracts. As you have seen in other parts of contract law, express terms, in other words those terms that are chosen by the parties, become part of a contract either via signature on a document or notification. Signed terms are always incorporated, even if harsh, or not read or not understood. A good illustration of this rule is the case of Lestrange v. F. Graucob Limited, 1934. In this case, the buyer of an automatic slot machine signed and handed to the sellers an order form containing in ordinary print and writing the essential terms of the contract, and in small print certain special terms, one of which was, any express or implied condition, statement, or warranty, statutory or otherwise not stated herein, is hereby excluded. The sellers thereupon signed and handed to the buyer a printed order confirmation assenting to the terms in the order form. The machine was delivered by the sellers to the buyer, who paid to the sellers an installment of the price. The machine did not work satisfactorily, and the buyer brought an action against the sellers in the county court claiming, inter alia, damages for breach of an implied warranty that the machine was fit for the purpose for which it was sold. The sellers pleaded, inter alia, that the contract expressly provided for the exclusion of all implied warranties. The buyer replied that at the time when she signed the order form she had not read it and knew nothing of its contents, and that the clause excluding warranties could not easily be read owing to the smallness of the print. There was no evidence of any misrepresentation by the sellers to the buyer as to the terms of the contract. The court held that as the buyer had signed the written contract, and had not been induced to do so by any misrepresentation, she was bound by the terms of the contract, and it was wholly immaterial that she had not read it and did not know its contents, and that the action failed and the sellers were entitled to judgment. A hash judgment, you may think, but one that induces a degree of certainty into deal-making. Signing a document is a definitive demonstration of assent. Unless, of course, there is duress or misrepresentation. In Curtis v. Chemical Cleaning, 1951, when the plaintiff took a white satin dress to the defendant's shop to be cleaned, she was given a paper headed receipt and was asked by a shop assistant to sign it. The plaintiff inquired why her signature was required, and the assistant replied, in effect, that the defendants would not accept liability for certain specific risks, including the risk of damage by or to the beads and sequins with which the dress was trimmed. In fact, the receipt contained a condition that the cleaners accepted no liability for any damage however arising. When the dress was returned to the plaintiff, it was found to be stained, and she was awarded damages by the county court judge, who held that the defendants had been guilty of negligence and were not protected by their exemption clause by reason of misrepresentation as to its character. On appeal by the defendants, the court held that the defendants could not rely on the exemption clause because their assistant, by an innocent misrepresentation, had created a false impression in the mind of the plaintiff as to the extent of the exemption and thereby induced her to sign the receipt. Lord Justice Denning noted that any behavior, by word or conduct, was sufficient to be a misrepresentation if such as to mislead the other party about the existence or extent of the exemption. If it conveyed a false impression, that was enough. Such an impression might even be conveyed by simply handing the document to the customer as if it were a receipt, or by asking her to sign it without drawing attention to the condition. But what if a document is not signed? According to case law such as Chapelton v. Barry UDC, 1940, the document must be something that is recognizable as a contractual document to the reasonable person. Also, the person entering the contract must have had reasonable notice of the term. This last part is quite important, as what constitutes reasonable notice will depend on the circumstances, and crucially the nature of the terms in question. The standard rules on incorporation by notice can be found in cases such as Parker v. South Eastern Railway, 1877, Thompson v. London, Midland and Scotland Railway Co., 1930, Thornton v. Shoe Lane Parking, 1971, and Ollie v. Marlborough Court Hotel, 1949. We will focus here only on those clauses containing particularly onerous terms. As well as the ordinary rules on reasonable notice, special attention must be drawn to any unusual or onerous clause. Lord Denning in Spurling v. Bradshaw, 1956, and Thornton v. Shoe Lane Parking, 1971, picked up later in Interphoto Picture Library vs. Stiletto, 1989, created what has become known as the red hand rule, to describe the level of notice one needs to incorporate successfully particularly onerous terms, such as exclusion clauses. In Interphoto, the plaintiffs ran a photographic transparency lending library. Following a telephone inquiry by the defendants, the plaintiffs delivered to them 47 transparencies together with a delivery note containing 9 printed conditions. Condition 2 stipulated that all the transparencies had to be returned within 14 days of delivery, otherwise a holding fee of £5 a day and value-added tax would be charged for each transparency retained thereafter. The defendants, who had not used the plaintiff's services before, did not read the conditions and returned the transparencies 4 weeks later, whereupon the plaintiffs invoiced the defendants for £3,783.50. The defendants refused to pay and the plaintiffs brought an action to recover that sum. The judge gave judgment in favor of the plaintiffs for the amount claimed. On the defendant's appeal, the court held that where clauses incorporated into a contract contained a particularly onerous or unusual condition, the party seeking to enforce that condition had to show that it had been brought fairly and reasonably to the attention of the other party. That, since the plaintiffs had done nothing to draw the defendant's attention to Condition 2, the condition, per Lord Justice Dillon, never became a part of the contract or, per Lord Justice Bingham, the defendants were relieved from liability under the clause. The red hand rule operates sometimes when a contract term is so harsh, or so wide and destructive of rights, that, in order to give sufficient notice, it would need to be printed in red ink across the front of the document with a red hand pointing to it, or something equally startling. However, even if a term is incorporated properly into the contract, this does not mean that it will be effective. For this to happen, the term will also need to apply to the issue at hand, which brings us to the issue of construction. Saying that you can have a free ice cream if you come by the shop on Tuesday does not entitle you to one if you turn up on Wednesday. This is a silly example, but illustrates that the successful inclusion of a term in a contract will only have consequences to the extent that the clause covers the circumstances of the case. A key question in dealing with exclusion clauses therefore will be whether, once incorporated, the term is properly constructed. In other words, is the clause appropriately worded to cover what has occurred? A key concept in English law is that ambiguous clauses will be interpreted contra proferentum, against the party seeking to rely on them. This is particularly used for exclusion and limitation clauses, but is nonetheless a rule of general application. The burden of proof will be on the person trying to rely on the clause, to convince the court that the clause does in fact operate to limit their liability in the issue at hand. See Andrews v. Singer, 1934. A key illustration of the rule is attempts to exclude liability arising from negligence. The courts have ruled in numerous occasions that especially clear words must be used to exclude this type of liability, but if the contract term expressly mentions negligence, then effect must be given to it. The crucial issue is when there is no express reference, are the words used wide enough to cover negligence? In Canada Steamship Lines Limited v. The King, 1952, the duty of a court in approaching the consideration of clauses which purport to exempt one party to a contract from liability was summarized as follows. 1. If the clause contains language which expressly exempts a, the person in whose favor it is made, from the consequence of the negligence of his own servants, effect must be given to that provision. 2. If there is no express reference to negligence, the court must consider whether the words used are wide enough, in their ordinary meaning, to cover negligence on the part of the servants of A. If a doubt arises at this point, it must be resolved against A3. If the words used are wide enough for the above purpose, the court must then consider whether the head of damage may be based on some ground other than that of negligence. The other ground must not be so fanciful or remote that it cannot be supposed to have desired protection against it, but, subject to this qualification, the existence of a possible head of damage other than that of negligence is fatal to her even if the words used are, prima facie, wide enough to cover negligence on the part of his servants. A reference in a contractual document to the contract being subject to general conditions available on request is sufficient to incorporate into the contract the terms contained in the current edition of such conditions, as in Smith v South Wales Switchgear County Limited, 1978. But if the clause covers more than one type of liability, it may be taken to refer to non-negligent liability only. In White v. John Warwick & Co., 1953, the plaintiff hired a tradesman's cycle from the defendants. The defendants agreed to maintain the cycle in working order, and Clause 11 of the agreement provided, "Nothing in this agreement shall render the owners liable for any personal injuries." Quote, "While the plaintiff was riding the cycle, the saddle tilted forward, and he was thrown and injured." The court held that, although Clause 11 exempted the defendants, even if they were negligent, from their liability in contract, which was more strict than their liability in tort, it did not exempt them from liability in negligence. If there are two possible heads of liability on the part of a defendant, one for negligence, and the other a strict liability, an exemption clause will be construed, so far as possible, as exempting the defendant only from his strict liability and not as relieving him from his liability for negligence. Finally, remember that even where an exemption clause has been properly incorporated and even where on its true construction it covers the loss or damage which has occurred, there are still circumstances that may affect its validity, even before we consider the treatment of such clauses as unfair terms. For example, any contractual deal will fail if agreement to the terms has been the consequence of misrepresentation, defined as a false statement of fact that leads the other party to enter into a contract. The Unfair Contract Terms Act 1977 followed unsuccessful attempts by judges to develop common law principles which would control what were commonly regarded as unacceptably harsh exclusion clauses. For a summary of the development of rules about exclusion clauses, see Lord Denning's judgment in George Mitchell v. Finney Lockseeds, 1983. Note that UCTA does not lay down in general terms what is fair and unfair in contracts. UCTA generally applies only to the exclusion or limitation of business liabilities, i.e. liabilities arising in the course of a business, see S.1. In summary, we can say that despite its title, UCTA is not about unfair terms in general. It is, virtually, only about unfair exclusion clauses and limitation clauses. It says that some terms of this type can never be used, but others are rendered ineffective unless they are reasonable. It follows from the above that UCTA does not itself impose obligation on a party, it merely controls attempts to exclude or limit an obligation that would otherwise arise. UCTA amends general common law rules on exclusion and limitation in certain situations, and it can be helpful to think of UCTA and the common law as separate layers, when testing to see whether or not a term is unfair. UCTA divides clauses into three categories: those which are automatically ineffective, those which are effective if reasonable, and those which are unaffected by UCTA. One common error is to think that UCTA subjects all terms to a reasonableness test. It doesn't. Broadly, the effect of UCTA is to render void, or subject to a reasonable test, any clause which purports to exclude or limit liability on the following grounds: liability for the breach of implied terms about the quality of goods and title to them, liability for negligence, contractual or tortious, liability for the breach of express terms, consumer indemnity clauses. Let us now have a closer look at some of the key provisions of the Act. The scope of UCTA is limited in two important ways. Section 1 provides that it only applies to business liability, apart from SS 6 and 8, and Schedule 1 removes certain contracts from its scope, notably insurance contracts and contracts concerning interests in land. UCTA applies mainly to clauses seeking to exclude or limit liability for breach of contract. Liability for negligence arises where there is a breach of a term to take reasonable care, express or implied, for example, Section 13 SGSA 1982, or where an obligation to take care is imposed without a contract, e.g. by the law of tort. UCTA Section 2(1) provides that liability for personal injury resulting from negligence cannot be excluded at all by any contract term. UCTA Section 2(2) provides that liability for other types of loss resulting from negligence can be excluded if the reasonableness requirement is satisfied. This is tested using UCTA Section 11 alongside case law. These are the implied terms as you have seen in different parts of the module, which are based on the Sale of Goods Act 1979 and the Consumer Rights Act 2015 and are implied into the various contracts concerning goods. Clauses which purport to exclude liability for breach of these terms are not effective at all in a consumer contract and are subject to the test of reasonableness, Section 11 and case law, in other types of contract. UCTA is somewhat confusing because it deals with these terms in two sections 6 and 7. To clarify, Section 6 deals with issues about the quality and fitness of goods in sale and hire purchase contracts, while Section 7 deals with them in all other contracts under which possession or ownership of good passes, mainly contracts of hire and where goods and a service are provided together, work and materials contracts. The provisions are identical in their effect, and the only reason there are two sections instead of one is that in 1977 the implied terms dealt with in Section 7 were not derived from statute. They are now contained in the Supply of Goods and Services Act 1982. Section 3 UCTA is a general control of contract clauses. It has two parts, both of which apply to protect consumers, or anyone dealing on another standard terms. Section 3(2)(a) provides that a clause which excludes or restricts liability for breach is only valid if reasonable. This overlaps with the provisions about implied terms and negligence liability in Sections 2, 6 and 7 because those sections already subject such clauses to control. But it also applies where the term breached is an express term, or some implied term not covered by other sections of UCTA. Section 3(2)(b) provides that a clause cannot be an excuse to render a performance different from that which was reasonably expected, or to render no performance at all, unless such a clause is reasonable. The object of the Law Commission, Report Number 69, in including this subsection was to prevent defendants getting round Section 3(2)(a) by claiming that a clause does not restrict liability for breach because the effect of the clause is to leave a particular obligation out of the contract completely so that the question of breach does not or cannot arise. Its potential scope is large, because it makes reasonable expectation rather than a contract term the yardstick of liability. Consumers are treated differently from other contracting parties by Sections 3, 4, 6, and 7 of UCTA. It is important to note that for all other sections it does not matter whether the party concerned is a consumer or not. Section 12 defines dealing as consumer. This is defined as a relationship where one party deals in the course of a business and the other does not. Although in most cases it will be obvious whether someone deals as consumer, the meaning of consumer adopted in R&B Customs Brokers v. United Dominion Trust, 1988, means that businesses may sometimes be included. See also Stevenson v. Rogers, 1999. The meaning of reasonableness is something that requires our particular attention. Not all exclusion or limitation clauses are subjected to the test of reasonableness, a common mistaken assumption made by students. Instead, terms should only be so tested when another section of UCTA tells you to do so. The reasonableness test is relevant, and only relevant, under Sections 2, 2, 3, 4, 6, 3, 7, 3, and 8. Reasonableness is defined by Section 11 and, in some cases, Schedule 2 may also give guidance. The definition of reasonableness contained in the Act is quite vague, but has been interpreted many times by the courts, so we also need to use case law to help us when looking to see if a term is reasonable. If a term is found to be unreasonable, it will have no effect at all. It will be struck out of the contract and the court will not replace it with a reasonable exclusion clause. The decision in Gill v. Horatio Meyer, 1992, appears to mean that the reasonableness of a term will be judged not just in relation to the claim being brought, but in relation to any claim to which the term could apply. See George Mitchell v. Finney Lockseeds, 1983, for an illustration of the application of the test. The Consumer Rights Act came into force in October 2015. It consolidates and clarifies consumer rights. It does not affect business-to-business contracts, for which the provisions of the Sale of Goods Act 1979, Supply of Goods and Services Act 1982 and the Unfair Contract Terms Act 1977 remain in force as explained in your study guide and textbooks. However, where the contract is made between a business, trader, and a consumer, the law in relation to implied terms and exclusion clauses will undergo fundamental changes to the existing legislation, including the Unfair Terms in Consumer Contracts Regulations 1999, UTCCR, and the Consumer Protection, Distance Selling, Regulations 2000, the DSS. In Part 2, the Act provides a general safety net to prevent unfair terms, reflecting UTCCR provisions and contained in Schedule 2, which are outside the blacklist. In Part 1, Section 63 of Part 2 has a list of terms which may or must be regarded as unfair. This will need to be read in conjunction with S.64, which has a list of terms which cannot be assessed for fairness. In its treatment of what we call unfair terms, the Act moves closer to the European standards of fairness, as opposed to the UCTA language of reasonableness. For example, the reasonableness test from the UCTA is replaced by fairness, including for negligence, which makes it much more in line with the UTCCR. Certain key prohibitions, like the UCTA ban on attempts to exclude liability for death or personal injury, remain. Let us have a closer look at the provisions of the Act. It is worth noting at the outset that building on ECJ, CJEU jurisprudence, see Panan GSM-ZRT vs. Erzshay Bet Sustine Gyorfi, 2009, the Court can consider unfairness in proceedings of its own motion. Section 71, general definitions are set out in Section 2 of Part 1a. Trader is a person acting for purposes relating to the person's trade, business, craft or profession. A consumer is an individual acting for purposes wholly or mainly outside the individual's trade, business, craft or profession. A person is not necessarily a consumer. This means that a business is defined much more in line with the principles of the UTTCR. So an incorporated business acting outside its normal course of business cannot fall within this but would need to rely on the existing legislation under the UCTA. Rights under the Consumer Rights Act make it easier to challenge hidden fees and charges. The key terms of a contract, including price, may be assessed for fairness unless they are both prominent and transparent. Terms which are not fair are not automatically binding on the consumer, but one may still rely on them if one chooses to do so. Some examples of terms that may be unfair under the Consumer Rights Act include fees and charges hidden in the small print, a term that tries to limit the consumer's legal rights, disproportionate default charges, excessive early termination charges. Section 62(1) of the CRA 2015 provides that an unfair term in a consumer contract shall not be binding on the consumer, with the test of unfairness is contained in Section 62(4), which states that a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. A term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. The fairness test thus includes the following main elements: significant imbalance to the detriment of the consumer and good faith. It must, however, be emphasized that the overall requirement is a unitary one. The question is whether a term is unfair. The elements of the test are recognized as being capable of overlapping with each other in their application to any particular set of relevant facts. Significant imbalance is concerned with the parties' rights and obligations under the contract. The requirement is met if a term is so weighted in favor of a business that it tilts the rights and obligations under the contract significantly in its favor, for instance by granting the trader undue discretion or imposing a disadvantageous burden on the consumer. Examples of the types of terms where an unfair imbalance is likely to arise include those that have the effect of restricting or excluding the consumer's normal legal rights, for instance, saying the consumer has no right to seek damages where the trader is at fault, constraining the consumer from seeking the legal remedies to which their rights give rise, for instance, compelling the consumer to take a dispute to arbitration, and imposing on the consumer additional obligations or risks which are not envisaged by law or unreasonably go beyond anything needed to protect the legitimate interests of the trader, for instance, imposing excessive financial sanctions on the consumer for breaching the contract. The above examples come from Schedule 2 to the CRA 2015, consisting of an indicative and illustrative list of terms that may be regarded as unfair, will offer significant guidance as to the application of the unfairness test. The inclusion of a term on the list does not necessarily mean that any clause of that type will be unfair. It will depend on the context in which it is put forward. Neither is the list exhaustive, meaning that a clause of a type that does not appear in it may nevertheless be found to be unfair. The list contains some provisions that are familiar from the controls imposed by the UCTA 1977, such as clauses allowing the seller or supplier to provide inadequate performance, or a different product or service from that contracted for. Other provisions reflect the common law rules relating to exclusion clauses, such as the restriction on clauses with which the consumer had no real opportunity of becoming acquainted before the contract. In general, the list is concerned with clauses that allow the seller or supplier to impose on the consumer, for example, by allowing the seller or supplier to cancel the contract without notice, or giving the seller or supplier exclusive rights of interpretation, or requiring the consumer to pay disproportionately high compensation for a breach. It is important to remember that a term or notice that is unfair is not legally binding on consumers. This does not prevent consumers from relying on it if they wish. The Act enables consumers to challenge wording if they consider it unfair and do not wish it to be relied upon as against them. What this means for students of contract law is that the unfair terms legislation now consists of a dual reading of UCTA in the CRA, as opposed to UCTA in the unfair terms in consumer contracts regulations, but the approach remains broadly consistent. And just like this, you made it to the end of our marathon session on contractual terms, breach, remedies and exclusion clauses. Check out the playlist on your screen for our other long lectures and click the like button so more people can benefit. Thank you for listening and see you next time.